morning. Be seated. Too many papers. Now is the time set for oral argument in cause number 1CA TX19-0001, Harold Vangilder versus the Arizona Department of Revenue et al. For everybody's information, these proceedings are being both audio and video recorded, which should probably come as a shock to no one. We also now have live streaming, so whatever that means, enjoy it. Barring any unforeseen problems, you can critique yourself on YouTube or on the live streaming in a couple of weeks. Counsel, each side will be entitled to 20 minutes, the standard period of time, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking up all of your time. No promises. However, ultimately, your reserving of rebuttal time will be up to you. We've reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in figuring out how you want to focus and how you want to address the court. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And before we begin, the ADOR is where here, sir? Okay, all right, gotcha. And you two have worked out the time issue between you?
Yes, sir.
And counsel, if you would please begin.
Thank you, Your Honor. Good morning. Patrick Irvin for Pinal County and the Pinal Regional Transportation Authority, the RTA. This case comes down to two statutes that are interrelated that provide for how the RTA and the county get approval for and then levy a county transportation excise tax, which is a very specialized tax that applies to a special district, which is what the RTA is. And those statutes, we have to look at them both for a number of reasons because they govern the case, they control the case, but we have to look at the statutes to see what they require with great specificity in some cases, what they require sometimes with less specificity, and they actually give choices to the RTA and the county as to how they do things, and things they just do not require at all that is open, that can be done but are not prohibited, and that reflects the legislative intent to not require them in this process. This is not a city or a county or the county with general government authority. This is a special district. The two statutes specifically apply as to how it's done to create the county transportation excise tax. And here the voters approved that at election that was consistent with the statute. And the ballot that they looked at was prepared consistent with the statute. The publicity pamphlet that they were provided was required by the statute and was provided for them. And in the statute, with great specificity, the legislature said the ballot shall include certain language. It didn't just say put in whatever you're going to propose, because the county transportation excise tax is a specialized tax. It's really defined in the statute as to what it means. And so the legislature says on the ballot, you shall put certain language. And the ballot shall say relating to county transportation excise sales tax. And the question to the voters shall be, do you favor the levy of a transaction privilege sales tax for regional transportation purposes, including at a variable or modified rate in Pinal County? Except for the modified variable rate, that's exactly the language that's required by the statute, very specifically required. It could not be varied. What we have here, though, of course, is there is some language in the statute that is required, but not so specific, which is the statute says you can impose a variable or modified rate, but the variable rate has to be in the ballot language, and the modified rate has to be approved by the majority. I think in both cases, the county and the RTA looked at that and said, well, it's really saying you need to put that language on the ballot. And so what's been done is a very specific language that's asked, do you favor the imposition, is then joined with the less specific language, which is how you define the variable or modified rate.
Let's go back one step. And then we want to know about variable or modified too, but one of the county's arguments is that this is barred, the whole attack, the whole challenge is barred for failure to mount a pre-election challenge. What's the best case or two for the proposition that the June resolution by the RTA was akin to a petition or another measure by which someone asked that something be put on the ballot? And the reasoning would be that if you don't challenge that before it gets on the ballot, we look at what the voters enacted, not what came before. What should we look at for that law?
And I think our argument is a little more nuanced, in the sense of that there are various arguments that are being made to attack the transportation excise tax. And the idea that it had to be challenged before the election, the greater strength goes to some of those arguments than others. The resolution 2017-1, I think it goes full bore. If you wanted to say there was deficiencies in that resolution that somehow affected the election, that had to be brought before the election because it's procedural. It's as to something that happened before the election. The variable modified rate is a little different because that's more substantive.
That's different.
Yeah,
But
and I think there's still an argument to be made, but it's much weaker. And the language of the ballot, it sort of falls in the middle, that to the extent the argument is the ballot language has to be interpreted in the context of resolution 2017-1, that had to be brought before the election.
because that argument is you're putting something on the ballot that's not in the resolution.
Yeah, that's totally illegal. The language itself is illegal because of the deficiencies in the resolution. And the best case for that, I think, there are a whole number of cases, but the Zajac case that we cite, the Casa Grande case, where it said, if there are errors in notice, if there are errors in the process before the election, as long as the voters approved it, it had to be done. So as I say, our argument is a little more nuanced. It's not all or nothing. I think the variable or modified rate is more the substance. But when it comes to any argument that's based on deficiencies in the resolution in June of 2017 that somehow affected, and I think that's where the trial court went wrong. He said this is a city, they're acting in their legislative capacity, and to put legislation on the ballot, they had to dot their I's and cross their T's. But that's not what was required. The RTA has no legislative authority except to levy a tax after the voters approve it. That's their only legislative authority. They were not acting in a legislative capacity with resolution 2017-1.
Okay.
And that was procedural.
What can we look to tell us what variable and modified means as used in the statute here?
I think given that there's no definition, I think you have to look at the common meaning of the words. And we've cited those as being that, able or apt to be changed, or to make basic or fundamental changes. And I think you can look back to the 1990 legislation that first put those words in the statute, where the legislature said, we want the RTAs and the counties to be able to make, the exact language was, certain unique strategies. I don't think a unique strategy would be phasing it in over a couple years. I think the legislature is more creative than that. They didn't know what Pinal County or other counties might come up with. They left it to them and said variable or modified rate. It varies. It varies based on the size of the transaction. No transaction is not taxed under the Pinal County transportation excise tax. And again, it's important to remember that's a very finely defined term. The voters approved and said they favored a transportation excise tax, which covers all the classifications. But because the statute requires language on the ballot materials to talk about variable or modified, that was put there and it defined quite carefully. But in terms of how you define it, it's changes. The legislature can narrow that if they want to, but the basic definitions that have been included cover that. And as we say in the pleadings, the county didn't pull this out of thin air. This is what cities have been doing for a long time, where they have the different rates applying to different amounts of the transaction. So we didn't invent something that was totally outside the scope of the Arizona tax system.
And you cite a section of the Model City tax code.
Right.
Is there anything that, in speaking of that section, I thought it was 5, but it's V.
V,
V,
option V.
is there anything that calls that a variable or modified rate?
I haven't seen anything.
Uses that
I mean,
adjective.
there are a number
Okay.
of cases, the amicus cites some cases out of state which are helpful only to show that variable means different things. And that's helpful for us because it shows that it falls within the universe of what is a variable rate, and it falls within the universe of what can be modified. It's got to mean something, and it doesn't mean what they say it means, because that's essentially putting their view of it. We rely on the dictionary definition, which says, able or apt to vary, so it defines itself, but subject to variation or change. That's what we have. It fits within the system. The Department of Revenue came up with a code pretty easily to do it. I'm sure there's a transition time, but it's the same thing 20 cities are doing. And to the extent there's any constitutional attacks on that, all of that's going to become constitutional too. But in terms of the statute gave the city or the county and the RTA the option. Here's something that the statute allowed. It required it to be on the ballot language, but it leaves wiggle room for the RTA to define what variable or modified means, subject to the voters' approval. They had to approve it. They were presented with this as, do you approve a transaction excise or transportation excise tax, including a retail tax with a variable or modified rate? They looked at the publicity pamphlet that defined it in great detail what that meant. And so to the extent there's a tax on that, the ballot language and the publicity pamphlet meet the requirements of the statute. And the argument that somebody could look at that and think it was only a retail tax just doesn't work when you look at the actual language of the ballot, particularly in the context of the publicity pamphlet, which the legislature provides for in detail. The rate of the tax is actually, by statute, in the publicity pamphlet, not on the ballot, unlike many other taxes by special districts. So to the extent you're looking at legislative intent, the legislature said, here's the very specific language you need to give the voters to ask them if they approve this tax. And that's the language that was there. They voted yes.
And in fact, that statute, your argument is that statute doesn't say that the ballot must include the rate. That statute says the rate must be specified in the pamphlet.
Yes.
Presumably because it's going to be complicated.
Right, exactly right. And there are many other taxes, specialized taxes, where the rate has to be on the ballot. But here, the legislative intent is the rate is in the publicity pamphlet. So those two documents really have to be looked at in tandem. That's what the voters look at. That's what they're going to understand they're voting yes or no on.
I suppose that would mean that although there's a lot of cases that say that you look, when you're dealing with something that was enacted a long time ago, you look to what the pamphlet said. Mm-hmm. What you're saying would mean the reliance on the pamphlet is even more apt, more helpful.
Absolutely, and that's based on the legislative intent in this particular statute. The idea that the legislature prescribes the form of the ballot and then says the publicity pamphlet shall have the rate, it'll have the duration. It has to have a fixed duration, 20 years. And that has to be in the publicity pamphlet. It could be lesser than that. But to the extent the voters know what they're voting on, they have to look at both the ballot and the publicity pamphlet. And that's the legislative intent. As I said, the legislature has been very specific about certain things. They've been required things without being specific, and certain things aren't required. And the level of detail that the plaintiffs have loaded on to Resolution 2017-1 just doesn't fit. The legislature didn't require that. Again, it's not legislation. The RTA was not enacting anything. They requested an election. And if you look at the record, everybody on the county side understood what was going on. The RTA enacted the resolution asking for a resolution or asking for an election on whether a transportation excise tax under the statute should be imposed. That's the title of the resolution. And because it's going to include a modified or variable rate, the resolution included that. The county, seeing that and understanding what was being asked for and not thinking that the RTA was asking for something that the plaintiffs say was illegal, which is only on retail, said we're going to set up an election on a county transportation excise tax, and we'll include the variable or modified rate. Voters approved that. The materials were sent out. The voters knew what they were doing. And then after that, pursuant to the statute, the RTA exercised what legislative authority it has, which was to levy the tax. But the
I'm not sure what that
continuous
means in
line.
this context.
What's
Does
that?
I'm not sure what that means in this context. Tell people they need to collect it
Well, if you
and
want.
and tell DOR to give it back?
If you're a taxpayer and you want to say, well, what's the tax on us? Well, here's the
Okay.
document that levies the tax.
Okay.
And so at some point, there has to be that level of detail in a document that somebody could come back and challenge. But that level of detail wasn't required in the resolution in June of 2017. And it wasn't even required on the ballot in November of 2017, but it was included in detail in the publicity pamphlet.
And the state has been collecting the tax on all classifications when the taxpayer makes the payment.
That's what I understand. And so the money's been held in escrow, so it's been, the money has been there, so it's gone through. But in terms of the attacks on the statute, as I say, the resolution, it shouldn't even be considered in the sense of if there are deficiencies in the resolution, that part of any challenge to the tax should have been brought before the election, because that's totally procedural. The Braden case that they talk about didn't have an election. In that case, there was a very specific statute that said you have to adopt a resolution, you have to give notice, you have to have a hearing, and after that you can levy the tax. No election at all. Here, the notice, the protection to the taxpayers, the protection to the public is all put on the election by the statute. The legislature has said the election with the ballot, the publicity pamphlet, that's the opportunity for the public to learn what this is about and vote yay or nay. Whereas in Braden, it was all as part of the internal hearings. If the RTA had just passed a resolution and asked for the tax to be collected without an election, then Braden would be relevant. But it just doesn't apply because it was very statute. Nothing with the resolution was intended under the statute to provide notice. It didn't have to be given notice to anybody except the Board of Supervisors, which, as I said, understood exactly what they wanted. I think the constitutional issues have been briefed endlessly, so unless you have questions, I'll reserve the rest of my time.
Thank you, Counsel.
Your Honors, and may it please the Court, I want to begin by making something absolutely crystal clear if I can. We are not arguing, and we have never argued in this case, that the tax placed on the ballot differs from the tax that was contemplated in the authorizing resolution. That's their argument. They're the ones who say that there were deficiencies in the authorizing resolution and then go on to argue that this Court need not concern itself with those deficiencies. We have never said that the tax in the authorizing resolution is something other than the tax that appeared on the ballot. That is, it was and is and always has been a tax only on retail sales. Now, the county's argument to try and say, no, it's a tax on all TPT classifications depends on two premises, which this Court should not accept. The first is that the Court can simply ignore the text of the authorizing resolution and treat it as though it didn't exist. They repeatedly say, well, the statute doesn't require that the authorizing resolution contains certain text, and that is true. But once the RTA has put that language into the authorizing resolution, the Court is not free to simply disregard that language because that language has binding effect. It's not simply a proposition placed before the voters. It's a resolution by a government agency adopted by elected officials that precipitates the process by which the election is held.
So the point that you're making is that we know from the authorizing resolution that this was intended to be just a sale, just a retail, a
That's
tax
right,
on
Your Honor.
retail. And we should, that should inform our interpretation of the ballot proposition.
That's right, Your Honor. And not only that, there's even more importantly than that is that the retail tax is the only tax that the county was then authorized to place on the ballot because the authorizing resolution specifies what the county then puts on the ballot.
But okay, take that as a given, but what do you do with the fact that the pamphlet goes on at great length about all the other classifications?
That would be relevant if this were a voter confusion case, which it's not. The question about whether voters were confused or something is not at issue in this case and never has been. And that's why all this stuff about whether the case should have been brought before the election and so forth is irrelevant. What matters here is what was the county authorized to place on the ballot? They were authorized to place the tax that was referred to in the authorizing resolution. Now, maybe the county, it's true, the county was not required to put any specific terms about the tax in the authorizing resolution. The RTA wasn't. But once they did so, then they were bound by that.
What's the law for that proposition?
Well, Your Honor, I think it's a general principle of law that the court is required to give legal effect to the words of any law that is adopted by a government agency. And their argument requires disregarding that. And their contention is that because their view is something along the lines of this: if the authorizing resolution said XYZ will be on the ballot, that the fact that what ended up on the ballot was only Z means that they can ignore X and Y. And that simply is unjustified. Courts are required, this is State Tax Commission versus Miami Copper, courts are required to adopt a strict construction of tax statutes, strictly against the government and against the taxing power and in favor of the taxpayer, and cannot strain, stretch, and struggle to uncover hidden taxable items. I love that phrase, because that's exactly what the county's doing, is it's straining, stretching, and struggling, trying to encourage the court to ignore the authorizing resolution. There's another reason why the authorizing resolution is relevant here. The statutes, that is 5314, statute that sets out the process for adopting one of these taxes, says the tax. It uses the word the. It says the tax that the RTA asks the county to place on the ballot shall be placed on the ballot. Not just any tax. The RTA couldn't, for example, say, well, we'd like the county to adopt an income tax. And then the county says, well, that's not lawful, so we're going to change that to a TPT tax and put that on the ballot. There's nothing in the law that allows them to do that. Counties only have the authority that the state gives them by statute, and nothing in the statute authorizes that. So it's true, you don't have to specify the terms of the tax, but when you do, that has binding effect, and it tied the county's hands here. Now, there's a second argument the county makes in trying to say, oh no, this tax wasn't limited to retail sales, and that's all the emphasis they put on the word including. It's really remarkable that the word including is the sole word on which their entire statutory argument is based. They say that the word including that appeared on the ballot means that this tax was a tax on retail sales including all the other TPT classifications also. And that, first of all, that puts way too much weight on the word including, as we show.
I think the argument is it's a tax it's an excise sales tax.
Yeah.
Generally, that includes a variable rate as to.
That is how they interpret the word including. And as we show on pages 14 and 15 of our first brief, that's an ungrammatical use of the word including.
But isn't it the case that all of your interpretations would take the word including out?
No, Your Honor, quite the contrary. Our interpretation says that the word including was adding this alleged variable modified rate to the retail tax. It says there is a retail tax including at this $10,000 carve-out. And their contention is the word including means that it's retail tax, and then the word including means included along with all the other TPT classifications.
But the word retail doesn't come before including, it comes after.
Well, it's not a very grammatically worded statute to begin with.
It's a badly worded.
And the authorizing resolution also contains various typographical errors and things, 0.005% instead of 5%, and so forth.
I mean, why aren't you attacking that?
Because because the best that it gets the county, if their argument of including has any weight, as far as it gets the county is to say it's ambiguous. The problem with that is, once again, the court is required to construe ambiguous tax statutes in favor of the taxpayer and against the government, and not to say that a tax applies to something not specifically covered by the language. In Corporation Commission versus Equitable Life, the court says courts should not extend a tax law to include something not specifically covered by the language. And their argument is that the word including implied that the tax was on all TPT classifications. But Arizona Tax Commission versus Staggs Realty says courts should not gather new objects of taxation by implication. And their entire argument rests on the implication from this word including. So even if the grammatical argument doesn't work, nevertheless, it still only gets the county to ambiguity, and ambiguity is insufficient here.
Let me argue with you on that, because it seems to me that the statute, and we'll set the pamphlet aside, but the statute or the proposition itself said levy of a transportation excise tax. And if they'd stopped there, that would have been sufficient under the statute. So how does adding and including, letting the taxpayers know, by the way, this is going to include a specific tax on retail that's going to actually hit you, how does that make them worse off?
Our position, and this is hard to do in oral argument, so our position is laid out in much more detail on pages 14 and 15 of our first brief. But the way they read the statute, they interpret the word including as meaning provided or however. By their interpretation of what was enacted, they would say that it read this way: do you favor the levy of a transportation excise sales, in parentheses, tax, on all TPT classifications, provided that it will be at a rate equal to 1/2, et cetera, et cetera. And that's just not what the word including means. It doesn't mean
I
provided
think it
or
means
however.
including. They say a transportation excise sales tax including this.
That includes the rate, right?
But that, including but not limited to.
And but
You're reading a but limited to into the including.
No, Your Honor, I don't think I mean to be doing that. What I mean is that the word including is properly understood to be an incorporation. And they're saying that it is a separation. They're saying that the addition of the word including, which did not appear in the authorizing resolution and which the county had no authority to place on the ballot in front of the voters, that the word including means that what was contemplated originally as a retail tax now means a tax on all TPT classifications, including retail, or rather including the carve-out. And what we're saying is no, the including the carve-out meant that this was a tax on retail sales, including the carve-out. I don't know if that's very clear, but note the difference here. The county's position is that the phrase means a tax on all TPT classifications provided that it will be at a rate equal to such and such. And our view is that it should be read this way: do you favor the levy of a transportation excise sales tax, including at a rate of 0.5%, ... upon every person engaged in retail sales? So the placement of the word including makes more sense in our reading than it does in their reading, because what it means is that it's a tax, and then parenthetically, including at this discounted rate, close parentheses, on retail sales. That's the natural way to read this. So their argument of trying to use the word including to transform this tax from a retail-only tax that was contemplated by the RTA resolution into a tax on all TPT classifications, including my clients, the restaurateurs, is vastly overweighs the word including and violates the rules of grammar. And even if it were consistent with the rules of grammar, it would be at best ambiguous and therefore violate the rule
And
of
then we
strict
go to the
interpretation.
pamphlet.
Well, not necessarily, Your Honor, no, because this is a statutory argument. It's not a question about what the voters understood. It's a question about what the county had the authority to do. And the county had the authority to place a retail-only sales tax, period, because that's what the RTA resolution contemplated, and that is, in fact, what they did. What they did was put on the ballot a retail-only sales tax. Now, in fact, post-litigation, they say, no, it was all TPT classifications all along.
Oh, but that's in the pamphlet. You're not saying that they changed the tax, changed the interpretation of the tax after the election, are you?
Your
How
Honor,
can you
I
say
think
that in view of the pamphlet?
I think this process was, this is the first case to be brought under this statute. I think there's not a lot of experience among a lot of lawyers about how to apply this statute. So I think there was kind of a catch as catch can as this process was going underway. So I don't want to make any claims about what the county contemplated in putting things in the ballot pamphlet and so forth, because it's not necessary for this court to get into that. All that's necessary is what the tax court did, which was to say, you have a statutory process here. It says authorizing resolution is adopted that says we'd like this tax. Then the county takes that and puts that tax on the ballot, and the voters approve it or disapprove it. Here, the RTA said retail-only sales tax. The county put a retail-only sales tax on the ballot, and that's unlawful, therefore, end of story. Second argument is the RTA contemplated a retail-only sales tax. County put a different tax on the ballot. Well, they have no authority to do that, so once again, plaintiffs win the case. That's the proper analysis here. Now, I want to make one little point before I hand the podium over to my colleague, and that is it would be very bad policy to say that the language of an RTA resolution that gets a lot of media attention in the county, that people pay a lot of attention to, voters paying attention to, if that's our concern, that the RTA language, they can do whatever they want in the RTA resolution, and none of that's binding, and the county can then put on the ballot whatever kind of tax it thinks to be lawful. That would be a very undemocratic and dangerous and a process that the statutes simply do not allow. The county is given specific statutory authorization to place this tax, the tax contemplated by the RTA resolution, on the ballot. That is what they did, but that tax is unlawful. No further questions. I'll hand over the podium, Your Honor.
Thank you.
Thank you.
Scott Teasdale, representing the Arizona Department of Revenue. The Department of Revenue is very concerned that the county is, with the carve-out in the retail, attempting to alter the statutory tax base. County cannot impose a transportation excise tax on only a portion of the gross income that is part of the tax base using the artifice of a zero rate.
And what's the authority for that?
It is the way the tax system operates. If they could do this, they could say, we're going to have a 0.5% rate on the retail classification, but a 0% rate on all revenues from auto sales. Well, autos are tangible personal property, and the retail classification applies to businesses selling tangible personal property at retail, measured by the gross income or the gross proceeds of sales. All this statute allows a county to do is adopt a rate which plugs into an existing system. This statute does not create an entire new taxing system.
Okay, so tell us what variable and modified mean by way of example or legal authority, please.
Certainly. The word variable when it comes to rates is obviously applied in a lot of contexts, most typically in finance, where an interest rate will adjust when it's pegged to an index at some regular period. So at different periods of time, it's going to apply there. In terms of a variable rate in tax statutes, it's usually not used. Typically, if you have multiple rates, that's referred to as a progressive tax system. If they go up at higher amounts of revenue, or in this case, it could be called a regressive tax, since they are lowering the rate on higher amounts of revenue on single items.
But
it was used in this statute, so
Well, yes, it was.
can you cite an example of a court or statute that says this is a variable rate, or this is an example?
We haven't found anything analogous.
Okay.
Where a court said this, but variable means it changes. There is no variation here, Your Honor. You have effectively one rate. You have a 0.5% rate, and then you have a non-tax, a zero rate. I think if the legislature passed a tax tomorrow saying everyone's income is going to be subjected to an additional income tax at 0%.
But you would be back here tomorrow if the county said an infinitesimal amount on the amount above 10,000. So.
Yes, Your Honor, and that's because it's a base division issue.
Okay.
Up until this tax, there was, for the retail classification, every other classification, there's a unified tax system in which there's a combined tax base with one tax base, one reporting code, and one combined state and county tax rate that applied to set the combined state and county tax. The counties simply ride along with what the state is doing, but adopt rates.
Does the state also collect the taxes paid under the Model City tax code?
Yes, Your
provision?
Honor. The state is now collecting.
We're told there are 20 cities that have a rate like this.
Yes, Your Honor, but it's a completely separate tax code. The Model City tax code is not the state's tax code. The legislature adopted a statute that created the Model City Tax Commission, which created a separate tax code. And the Model City Tax Commission is more or less controlled by the cities, and they chose to adopt that. And the legislature has not intervened to stop it, but that is not the tax system that the counties operate under. The counties operate under the state's transaction privilege tax system.
Okay, so what could variable mean then if it doesn't mean that?
Very, very simple. It varies over time. We're adopting we're phasing it in, a 0.2% rate, next year 0.3% rate, and modified is even simpler. The statute simply gives the voters the right to modify the rate after they've adopted a rate. So if they adopted a 0.3% rate and they wanted to bump it up in a later election, modified clearly refers to a new act by the electors. And nothing's been modified here, and nothing varies here.
What's your support for that? You said clearly, and I remember a law school professor told me always pause when someone says clearly. So what's your support?
Certainly, the statutory language, Your Honor. When I say clearly, I'm referring to the statutory language. If we look at C, the last sentence of C in 42-6106 says, the department shall collect the tax at a modified rate if approved by the majority of the qualified electors voting. Again, that's referring to the electors
And that
modifying
clearly
the rate.
specifies they're talking about a change from, in an intervening election.
I think that a modification
it's not
necessarily
quite so
implies a
clear.
change as opposed to creating a multiple tiered system that where rates would vary over time, which we would interpret as a variable rate.
Counsel, are you saying that never in statute has the state used language indicating a 0% tax? Never happened? You've never done that?
I haven't done a survey of every tax enactment where they use a zero rate. Typically, though, that's effectively an exemption or a deduction. It's very common in income taxes to exempt portions of proceeds so that you will have in a tax table, for example, 0% on your first X number of dollars, and then over that, they start applying a positive rate. But typically, that's just in a tax table where there are deductions or exemptions.
Well, even in the sales tax, doesn't the legislature, and correct me if I'm wrong, exempt certain purchases from the sales tax altogether?
Exemptions are different than the statutory tax base. And the transaction privilege tax is not a tax on individual sales. It's a tax on the privilege of doing business in a classification measured by the gross proceeds of that business.
But then certain things are excluded from the gross proceeds.
Yes, deductions and exemptions look at individual transactions.
And
if you
sandwiches, for example, I remember there was a hullabaloo about sandwiches a while back.
Well, I don't recall the hullabaloo about sandwiches, but deductions and exemptions do look at individual transactions, and they're reported separately. All right, on the front of your TPT-1 form, you're going to have your gross, and then you have deductions, which you have to then write in on the back of the TPT-1 form, documenting the individual deductions. But for the gross income, no, it's not handled that way. And again, this is a coherent system. The county has the idea that because variable and modified appear in this, counties have carte blanche to tax something and not tax something, and that ignores the fact that this plugs into the entire transaction privilege tax system, where you do have taxable acts, you have tax bases, you do have statutory deductions. Again, they are effectively adopting, with this rubric of a zero rate, a deduction of proceeds from the statutory tax base.
So what your argument is that we have these 15 or 16 classifications, and the only power that the county has here is to impose a tax on each of the classifications. I presume it could have imposed a different rate on the various classifications?
I don't think so, Your Honor, not in the language of the statute. I think they basically had to adopt a percentage of
the same percentage
of the state's rate. Typically, that's worked is we've got a 5% state rate, and they adopted the 10% of that.
Right, but
there are a few small classifications that have lower rates than 5, so they don't get the 0.5 on those. So there is some difference there.
The argument is the county only had the power to impose a uniform rate on all the classifications together, one rate on all the classifications.
Yes, all the classifications are subject to the 0.5 rate, with the 10% would be that.
Okay.
And
So variable means then?
Variable in our view, when you've got a system, let me, excuse me, I'm out of time, but I will try to address this and what the problem is with their theory of variable. Can they do 0.1 on Monday, 0.2 on Tuesday? Can they break the tax base up into 10 different categories? So we and taxpayers have to look at 10 different reporting categories with different rates applying in the same month for a monthly reporting system?
So what you're talking about now is there's a retail sales, the classification, and what you're talking about now is where a county would say, we're going to take car dealers out of this, and we're going to deal with revenues from sales of autos at a different rate. You're saying you can't do that?
Yes, that's
Among
exactly
other
what I'm
things you
saying.
can't do.
Among other
Okay,
things you
yeah.
can't you can't do, and you can't say this type of this type of property sold at retail, we're going to tax at this rate. This type we're going to pass at this rate. Because each time you do that, you're subdividing the unified tax base for the retail classification and creating a new category. Each classification has its own coding, And now with this county, now we've got two codings. Is it going to be 3? Is it going to be 4? Is that going to be multiplied through every county? And the department can change its computer systems, but taxpayers have to deal with this. And we're trying to move toward simplification in this state, not create chaos every time a political subdivision decides to do something.
Thank you, counsel.
Do you have
Thank
any more?
Jim, did you have something?
No.
Thank you.
Thank you. In 1990, legislature put variable and modified in the statute. And in the legislative intent said, we want to encourage certain unique strategies. Mr. Teasdale says this is the first county that's done it. That's the definition of unique. It's got to be somebody first. And so the fact that nobody thought of it legally is not a reason to do it, because the legislature meant something by that. It could have easily said you can phase it in over time. It could easily say you can modify it in a later election. But that's not what the statute says. It says you can modify it. You can modify the standard rate, which is in the publicity pamphlet, but it's got to be on the ballot. You know, if you're going to change from the standard that applies to everything. I'm trying to picture a purchaser going in to buy a high dollar item, and he asks the salesman, what's the tax rate going to be on this? And the salesman, I can almost picture this, is going to say, well, it's going to vary depending on whether you buy 20,000 or 30,000. What's different here is the rate on that sale. Nothing is left out. There's nothing left out of the base in terms of transactions. There's no cars left out, no tractors left out. Everything's taxable. But the rate is going to vary once you go over $10,000 because the legislature allowed this unique strategy that's available to the county. And maybe nobody's ever done it before, but that's what makes it unique.
So I'd be interested in hearing your response to the argument that because the original RTA resolution only mentioned retail sales tax, that the county lacked the power to put more than that on the ballot.
That argument is premised on the idea that the county was required to do an illegal act, which is to put on the ballot an illegal proposition. They're saying a retail only is illegal. The county understood that what was being asked was a legal election on a legal act, which was adopting or asking voters whether they approve the adoption of a county transportation excise tax. And that's what was put on the ballot. And the voters saw that. They looked at the ballot language. As you mentioned, the basic language is required by the statute. Everything starting with including after relates to the modified and variable rate. Because the overall tax includes a retail tax with a modified variable rate. So the basic statutory language is enough for the voters to adopt the transportation excise tax. What happened with the resolution, as I say, to the extent there were deficiencies, that is a procedural thing which definitely had to be brought before the election. And if it had, we wouldn't be standing here and the money wouldn't be piling up in escrow because that issue would have been resolved before. In terms of the voter confusion, there certainly wasn't any if you look at the ballot proposition and the publicity pamphlet. But we certainly disagree that the voters thought they were voting on retail only. You can't read the ballot proposition, the publicity pamphlet, and think that. And no voter was thinking, well, I remember 6 months ago there was a resolution which was never published, never sent to me, but it said something. But again, the statute does not make that resolution the law. It cannot withstand that weight. The RTA did not have the authority to enact a law in that resolution. And
So setting aside the argument that they should have brought a pre-ballot challenge to this, like the opposing counsel said, if the RTA had said, we think excise taxes are regressive, so let's propose a 1% income tax here in the county capped at $10,000. And the board of supervisors got that and said, well, that'd be illegal, so we'll just do an excise tax instead. Would that be okay?
Well, I think what was presented to the voters was legal, and that's why that's our first
I
argument.
get that,
really.
but
Yeah,
I'm saying
yeah.
if the RTA had proposed a income tax instead, would the county have been allowed to put this excise tax on the ballot?
I think if the county understood that what they were really asking was for a tax under the statute, which is a county transportation excise tax. The language, it might have been deficient, it might have been wrong, but if the county understood that their intent, and they say the intent has been the same all along, the RTA to the election to the levy and the tax, to impose a county transportation excise tax with the addition of the variable and modified rate. And that has been consistent. But I don't think we can put aside the idea that to the extent there's a procedural error related to the resolution, that had to be brought as an election challenge, because that's totally procedural. And what was presented to the voters was consistent with the statute. It specifically complied with the statute to the extent it had specific requirements, and tied the remaining part together in a way that the voters knew exactly what they were voting for.
How did the board know what the RTA really intended?
Well, the title of the resolution says, we want to ask for a resolution the issue of imposing a county transportation excise tax pursuant to the statute, and it named the statute. Down below, after the whereases, it talked about the variable rate. But I think the intent of the county, or the RTA, was always clear that this was a tax. There were revenue projections that were based on that. Everyone got together and put together the publicity pamphlet and the ballot. And to the extent there were any deficiencies, the voters were presented with the language that specifically came out of the statute.
Does the record tell us anything about any overlapping membership or staffing of the RTA on the one hand and the Board of Supervisors on the other?
It's a small county. They work together. I know that the board of the RTA is mainly mayors of the towns, so I don't know that there's any overlap in the boards, but
Okay.
But they certainly work together. And if you look up the RTA's website, it sort of falls under the county, and so it's technically separate, but they all work together. Thank you very much.
Thank you.
Thank you. Such an uncomplicated issue, huh? We do appreciate the argument. We appreciate your attention and your passion for the argument. We are going to conclude at this time. We're going to take the matter under advisement, and we'll be back to you in due course. Well, gentlemen.
I was so frustrated that I got a citation about the word "be."